Suppose you are a judicial magistrate in your court. If any accused person reaches to your court or begin to abuse you, what will you do?
So in that case, I can take cognizance and put. So in that case, I may take cognizance and may, since it is a contempt of the court, I can put him behind the bars for a day or so that he won't repeat it again. Sir.
What is the cognizance?
So cognizance here. Sorry.
In which section?
So I'm not able to recall the section, sir.
Can you say what the meaning of the cognizance?
Yes, sir. So the cognizance means taking up any case by the judicial magistrate, which he has the power to adjudicate upon, and it is in the CRPC it is mentioned under section 190, and it means that if any information is received by the magistrate or any police report or by any complaint, the magistrate can take cognizance of any case.
What is the difference between judicial magistrate first class and chief judicial magistrate?
So the major difference is on the power. So the power of a chief judicial magistrate is to punish any person till the year of 7 years,
Yeah.
and any fine. So, but the chief judicial magistrate of first class, he may give punishment up till 3 years and fine up to 10 years. So. And it is the judicial magistrate of first class is generally subordinate to chief judicial magistrate, and chief judicial magistrate is the one who gives the case, who transfers the case on who take cognizance of the case and transfers the case to the chief judicial magistrate first class and judicial magistrate second class.
What are the importance of yoga?
Yoga. Yes, so it helps. It is a very good stress buster. It helps in meditation. It keeps the mind cool, and it is very good for posture and well-being of an individual.
What are the difference between civil judge and DSP?
Civil judge and DSP. So civil judge is basically, he has to take care of the legal matters of the part, but the DSP, he has to take the administrative part of the society.
Okay, introduce yourself without stating your name,
Yes.
hobbies and educational qualification, and specify your passion as well, right?
Okay, sir. So I'm enthusiastic and determined girl. So further, or my hobby. I've done my schooling, that is class 10.
Educational background. I think that.
Sorry, sir. So I am an enthusiastic and determined girl. So I am a very hardworking and a patient person. I am a good listener, and I encourage criticism so that I can work upon my shortcomings. And I think my weakness is that I think I am a bit over ambitious, which sometimes lead to stress. And so these are.
How many yards badminton has?
Sorry, sir.
You have hobby, right? You should
Yes.
work on it, right? Now, ban on liquor, right?
Yes.
There are ban on liquor on some states. Which part of the PSP it comes from? Means the basic idea of ban of liquor.
So I think that for the well-being of the society under Article 47 of the Constitution, sir. So in which the health and the well-being of the society comes into play.
Are you sure?
Sorry, sir.
Okay, can you please say me that whether it is in liberal philosophy, Gandhian philosophy, or socialist philosophy?
So socialist philosophy.
Okay. There is a controversy right now, right, in these days, that pardoning power of governor, right, interferes with CRPC. Which section of CRPC?
Pardoning power of governor.
Interferes with which section of CRPC?
Sorry, sir.
Alright. The responsibility of writ jurisdiction, right,
Yes.
is greater for high courts as compared to Supreme Court.
Yes.
Why?
Sir, in High Court, mainly all the matters which are interest of the society, that is the public interest, it can be taken up and it could be addressed more comprehensively. And since the Supreme Court being the only apex court of the country, so in this, so there is some scarcity of time as well. So the major power has been given to the High Court in order to address such issues.
Name all the jurisdiction of Supreme Court.
Sir, original jurisdiction, appellant jurisdiction, advisory jurisdiction.
What is the role of re-examination?
Ma'am, the role of re-examination is merely to explain the facts which has been asked to the accused in cross-examination.
What is the difference between admission and confession?
The main difference is that the confession, it is given by any person, any accused person, and he is inflicting himself that he has also done some act. It is inculpatory in nature. For the admission, it is a broad statement which includes confession as well, and it could be given by any person in regard to anything. And confession, it is generally barred under section 24 and 25, that could not be given in front of the police officer or in front of or in the police station, except in presence of the magistrate. This does not apply in case of admission. It could be given by any.
What is the difference between motive and intention?
Sorry, ma'am, I'm not. I'm not able to recall right now.
What is inquiry report?
Sorry, ma'am.
Inquiry report?
In inquest reports, ma'am, it is given under section 173 of the Criminal Procedure Code, in which that any offence which has been done in regard to if any person has died by any animal, or if there is any suicide case, or by any person, or in an accident, and it is not the cause of action of such grave offence has not been well known, then such an inquest report is done by the police officer and before informing the magistrate, and further it could be done by the magistrate in case of rape, or in case of murder as well.
Explain about fact in issue.
Fact and issue. Fact and issue means any fact which either by itself or by in relation to any other fact which takes place in regard to any existence or non-existence of fact and issue, or which puts any which takes into account any ability, disability, or any right of any person. In this regard, it is called fact and issue. It could be asserted or denied as well.
Cross-examination?
Cross-examination, it is taken generally by the other party, by the other advocate from the accused, in order to verify any fact, or in order to get the facts checked. It is done. It is done by other advocate to so that the truth could be taken out from the witness. It is called cross-examination.
Explain about dying declaration.
Ma'am, dying declaration, it has been given under section 32, clause 1 of the Indian Evidence Act. It tells about if any person when if he dies and he tells about the cause of action or the transaction in which his death has been caused. In this regard, all the statement would be considered as the dying declaration, and it's generally considered as truth because it is established that no one dies with a lie on his lips.
What is the difference between bailable offence and non-bailable offence?
Sir, generally the bailable offence is the one in which after giving the security, after signing the bond and the security, a person gets the bail. But in non-bailable offence, the discretion lies upon the court, the judicial magistrate has to see whether there are some. Has to determine whether he can be left on bail or not, and he can give his discretion by seeing whether there is any antecedent, whether he may leave the jurisdiction of the he may leave India, or he may tamper any evidence, or he may with promise in threat or threat, etc. These things he can tell other witness not to proceed against him. So all these things would be taken into account, and after that only, if the judicial magistrate seems fit, then only he will give bail.
How to decide bailable offence and non-bailable offence? How to decide?
Sir, it is given under Schedule 1 of the CRP of the Code of Criminal Procedure Code, and which the offences are mentioned, whether it is a bailable offence or non-bailable offence.
If there is a case of the Arms Act or Forest Act, how to decide the bailable or non-bailable?
Sir, in first schedule, but part 2, it has been also mentioned that in regard to the other offences, so in that case, if the punishment is given of more than 7 years, then it will be a non-bailable offence. Again, if the punishment is of 3 to 7 years, it will again be a non-bailable offence. But if it is less than 3 years, it will be a bailable offence.
What is the difference between agreement and contract?
So the agreement, the basic criteria of agreement is that there should be a competent party, there should be a legitimate object, consideration. So further, it should be consideration. So all these things, but the main difference is that if the agreement is enforceable by law, it becomes a contract. If not, then it remains an agreement. So
In agreement enforceable by law?
agreement enforceable by law, then
the
it
contract?
becomes a contract.
Oh, agreement enforceable by become contract. Okay, good. Now, what is the natural justice in accordance with administrative law?
Sir, natural justice, it means that everybody should, there are certain principles that everybody should be heard, given a chance to be heard in his own case. Sir, second, there should be a reasoned judgment, and third, sir, I'm not able to recall the third one, sir.
Okay. What is the anticipatory bail?
Anticipatory bail.
Yeah.
So under section 438 of the Code of Criminal Procedure Code, anticipatory bail has been mentioned. In this, if a person feels that if he has committed a non-bailable offence, then he can go to either High Court or Court of Session to grant him the anticipatory bail, in which even if any warrant is generated against him, then also he will get the bail. But the Session Court or the High Court has the discretion to whether to grant him such anticipatory bail or not.
What do you mean by police remand?
Police remand. So in this, if a person who is in the custody of the police officer, so it is called a police remand, sir.
Custody of?
Police.
So how many days the magistrate can grant the police remand?
So for a maximum 50 days.
Okay. Can you? ठीक है ना? We are analysis here. Huh? हमारा इंटरव्यू खत्म हुआ।
खत्म कर।